Hello, everyone, and welcome to today's ENS webinar. I'll just say a few words before I introduce you to the rest of the panel. Just to say that I'm a director in the Banking and Finance Department, as is Era Gunning. Era needs no introduction. I think she is one of the, if not the leading, I think, experts on POPIA in South Africa. And another member of the panel is Vicky Borg-Jorgensen, who is in my team, and she will be joining Era in some parts of the presentation, just to give a bit more of a practical, some practical inputs on some of the contractual issues and so forth. And then just by way of context and background, some time ago, so let me just start by saying that, so my team, what we focus on is most forms of structured finance, and that ranges from debt restructurings to syndicated lending, DMTN programs, and in particular securitization. And so some time ago, while we were looking at securitization and thinking how POPIA may or may not apply in the context of securitization, it became quickly apparent to us that we need a proper analysis of this from ERA. And so the Securitization Forum tasked ERA with preparing a comprehensive analysis with our assistance of the applicability of POPIA to typical securitization transactions, which, as some of you will know, many of you will know, involves a number of role players, a number of series of transactions, and many of those role players will most likely be processing personal information. And so ERA then came up with this very comprehensive opinion, and flowing from that, we realized that not only is POPIA, the impact of POPIA is much more, goes much further than I think we initially thought. But in addition to that, many of the principles that ERA dealt with and the conclusions she reached will apply not only to securitization, but also to other similar transactions. Many of these conclusions would apply equally well to syndicated lending, potentially even debt restructurings where security SPV is being used and that type of thing. So we thought it would be useful to basically expand the audience a bit beyond the securitization market participants to all of you, and just to create some awareness around some of these issues, which we hope will be helpful. I think that's really all I need to say. I think just also during the course of this webinar, before I hand over to ERA, if you have questions, then click on the Q&A button, not the chat button. I think that's what we've been told to advise everyone. And then we'll do our best to try and get back to you on either live answers or otherwise, time permitting. But with no further ado, over to you, ERA.
There we go. I was on mute. Hope you can hear me now. Thank you very much for joining today's session. And yes, we are going to be discussing 10 things that banking and finance providers should know about the Protection of Personal Information Act, POPI, or POPIA, or the POPI Act, as some people call it. So without any further ado, we are going to be discussing where POPI comes from, who's POPI's mother, when does it apply, who are the role players. We are going to look at the difference between operators and responsible parties. And I'm very sure that many of you have been grappling with this, battling with it. It is so difficult to identify and practice who would be responsible parties, who would be operators. Hopefully today's webinar can help a bit with that, because we'll give you typical examples of operators in structured finance. We are going to look at the role of the information officer and the deputy information officer. We're going to touch upon who can go to jail. If anybody, I don't think anybody is going to go to jail. We're going to look at when personal information can be processed. We're going to look at trans-border transfers of personal information, prior authorization, security compromises or data breaches, and then non-compliance. So that is quite a lot of things we are going to look at. And Stephen and Vicky, as you know, I don't know structured finance or securitization well at all. I know it a lot better after the opinion because I myself watched a lot of YouTube videos to work out how it all would all tie in together. But if you do want to add anything, please just interrupt me at any stage. And yes, if we get time, we're going to get to your Q&A. If we don't get time for your Q&A, because we're covering quite a lot today, please just email us and we will happily get back to you. So first of all, where does POPI come from? Who is POPI's mother? Now, the OECD privacy guidelines were published in 1980, and that was basically where we saw this privacy principles or these conditions being born. And that was followed by the EU Directive on Data Protection, which came out in 1995. And as you may know, the EU directive was replaced by the General Data Protection Regulation, the GDPR, our celebrity data protection law, in May 2018. But POPI is not based on our GDPR or on the EU GDPR. It is based on the old EU directive. So the EU directive is POPI's mother. The OECD guidelines would be POPI's grandmother, and the GDPR would be our sister. Now, POPI specifically says when we battle to interpret the Act, we must look at international standards. And of course, whenever I get a legal opinion to write, the first thing I do is I check how have these provisions, the similar provisions, been interpreted in terms of the GDPR or the Data Protection Act in the UK, and we look at guidance from the Information Commissioner's Office in the UK and so on. But when it comes to structured finance and securitization and the application of the UK and the UK legislation and the GDPR, there is very, very little written about that. So I couldn't find much of use as far as the international standards are concerned. And that is not a surprise because the GDPR and the international laws only protect human being data subjects. POPI is different because we protect juristic persons as well as human being data. So you will know that POPI has been making for a very long time. It started already in 2009 as a bill, and then eventually, to cut a long story short, the majority of the provisions of the Act kicked in on the 1st of July or became effective on the 1st of July this year. I say the majority of the provisions because there's one little subsection, section 58.2, which has been delayed, and that is only going to kick in on 1 February next year. But there's been a little bit of misconception in the market where a lot of people think that POPI has been delayed. No, it was only that one little subsection that is going to kick in February next year. The rest kicked in about 3 weeks ago. So when does POPI apply? POPI applies when we process personal information, which is entered into a record, and that processing can occur by means of automated, computerized, or non-automated measures. And that personal information must be entered into a record, and this must happen by or for a responsible party who is either domiciled in South Africa or not domiciled in South Africa. So basically, as a general rule, if you touch personal information in South Africa, POPI kicks in. It doesn't care whether, POPI doesn't care where the company is located, where it is domiciled. It cares about the fact that personal information is being processed within the borders of South Africa. That is, of course, the general rule. So what is the processing of personal information? Processing is incredibly widely defined. It includes anything you do with personal information. If you just collect that information, if you store that information, if you share that information, if you record it, even if you delete information, it would be seen as the processing of personal information. But what is personal information? And that is so key here. Personal information is any information that relates to an identifiable living human being or existing juristic person, such as a company. Now, it includes many things like name and race and even a symbol, an identifying number, an email, a physical address, a telephone number. So any information that relates to an identifiable human being or company or trust or so on would be deemed to be personal information. And basically, if you do anything with personal information in South Africa, that is going to trigger the application of the Act. I see we've got a question here. Hi, Ira, can you talk more about automatic processing versus with profiling versus automatic processing without profiling? And if possible, an example of each. So profiling would be seen to be a type of processing. So whether you are profiling or not profiling, the fact that you are using personal information would be seen as the processing of personal information. Profiling is some sort of subcategory of a type of processing of personal information. If I didn't answer your question properly, please email me and I'm happy to touch base with you again after the session. We've touched on what processing is, and you will see that processing is so wide. Just merely recording information, collecting it, destroying it would be seen to be the processing of personal information. And I think every single person on this call today is processing personal information. So we get two broad categories of personal information. So we get the stuff that I have left in black, and that is ordinary personal information. And then we get the red flag information, things like race and sex, ethnicity. And POPIA has got a special definition for our red flag information. It calls it special personal information. Now, in a nutshell, your ordinary personal information, such as a person's name and contact details, even financial history, can be processed even if you don't have consent, provided you've got a valid lawful reason to do so. So lawful reasons would include it is in the organization's legitimate interests, it is in the data subject's legitimate interests, it is in a third party, including an organization's business partner's legitimate interests. We're giving effect to a contract, or we're doing it because the law says we must. So our ordinary personal information, we've got lots of excuses or loopholes to process ordinary personal information. But the minute we hit the red flag personal information, that is where our life becomes more complicated. So our special personal information, generally for special personal information, we need consent, unless there is, for example, a clear-cut law that says we must process the stuff like the employment equity legislation or the COVID regulations in respect of health information and so on. But without a clear-cut law or a right or an obligation in terms of law, consent is usually the default that we would rely on. There are other reasons to process special personal information as well, but where we do have consent, our life is a lot easier. Now, who are the role players in terms of POPIA? In terms of POPIA, we get the data subject. Now, the data subject, remember, can be a human being or it could be a juristic person. And then we get the responsible party. Now, the responsible party is called a data controller overseas. And the responsible party is that entity who decides what information to process. Why are we processing it? What are we going to do with that information? Who are we going to share that information with? And so on. And very important to note that each and every single entity in a group of companies is its own standalone responsible party. So each entity is a responsible party. So if you have dormant entities in a group, they would usually also be a responsible party if they process information in South Africa. If we've got SPVs, they would be their own responsible party. But very often, and we see this in structured finance a lot, the responsible party would use a third party to process the information on its behalf. It would use somebody else to do something with the personal information on its behalf. And that person we call an operator. Now, an operator is in a beautiful position in terms of POPI, because an operator only has 3 duties. An operator must keep information confidential. They mustn't do stuff with the data that the responsible party doesn't know about. And if there is a data breach, all they need to do is tell the responsible party. And if they breach these obligations, we don't have any penalties in terms of POPI. And that is why POPI makes it mandatory to enter into an operator agreement with the operators. So the responsible party and the operator must enter into a written agreement that imposes certain security measures, certain obligations as far as security of data is concerned on the operator. So this is absolutely crucial, and we are going to be speaking about that in as far as structured finance is concerned soon. And then, of course, we've got our information regulator, headed by Pansy Tlakula. This is the person where any person with a privacy concern can run to. It doesn't have to be a person who suffered any harm. It could, for example, be a disgruntled employee, a competitor, and so on. Okay, so responsible party, I include the definition of responsible party in the slides. I also include the definition of operator, and these slides will be shared with you. But what we want to get to is operators versus responsible parties in structured finance, and of course also in securitization. So we have been seeing operator agreements flying around left, right, and center because parties are battling to understand who is a responsible party and who's an operator. And by default, they've just been sending these operator agreements to all their suppliers, hoping that they catch all the operators in the net. So in finance, examples of those who would generally be responsible parties who will process information for its own purposes would, for example, be a borrower, an arranger, a lender, an issuer, or security SPV in securitization schemes. But then we also get the operators, and these are so crucial to identify. So the operators are the ones who act on documented instructions from the responsible party. They may have the know-how, or they may have the arms and legs to carry out the instructions, but they get told what to do with the data. And here we find entities such as fund administrators, distributors, a general partner, a manager, fund umbrella, a facility agent acting on behalf of a consortium of banks, entities such as data room providers, technology vendors, where data is not hosted on premises, outsourced back office providers, companies which store physical documents or dispose of confidential paperwork on our behalf, payroll firms, platform providers, alternative investment fund managers, and so on. So we will see that there are a whole host of operators that we do use in the space. And of course, we need to identify them, and we need to enter into those mandatory written agreements with them. These agreements are not a nice to have, they are a must have. And Vicky, I'm sure by now everybody is tired of my voice. Do you want to add anything here in the structured finance or securitization space?
Thank you so much, Ira. So this is so important, especially when it comes to the crafting of finance documents. So as Ira said, whenever an operator processes personal information on behalf of a responsible party, a written contract must be concluded between that operator and the responsible party. So this is mandatory in terms of POPI. It must be complied with. POPIA also sets out certain requirements that these agreements must comply with. It must, for instance, set out the technical and organizational security measures that these operators must comply with. And this is really a minimum requirement for these agreements. So I'm just going to use a securitization really as an example of when this type of arrangement might come up. So in a securitization, you would have an issuer SPV. This is not a normal operating type entity. It has no employees. It doesn't perform any functions itself. So it would appoint agents to act on its behalf. These agents would typically include administrators. The administrator will perform functions in respect of the operation of the issuer's business. A servicer will perform functions in respect of the issuer's assets. You would also have paying agents, transfer agents, settlement agents, collection agents. You'll have arrangers and dealers. And these agents will perform functions in respect of the notes and the note holders. So each of these entities will in one way or another process personal information on behalf of the issuer. So this may include information of note holders, names, registration numbers, addresses, even telephone numbers, information about shareholders, about directors. So it's so wide, this act. So whenever this type of processing happens on behalf of the issuer would need to enter into a written contract with the operators, so with each of these operators, so that it complies with POPIA. Now, in existing securitization programs, you would usually have all of these agreements in place. Well, agreements in place. And these agreements would not necessarily comply with all of the requirements of POPIA. So it wouldn't necessarily include technical and organizational security measures. So these agreements would need to be amended and updated to comply with POPIA. And this can be done by an addendum to each of these agreements, or where there's a common terms type agreement in a transaction, even by a general amendment to that common terms agreement to which all of these parties would be party. So that's for existing programs. And then going forward, of course, for new programs, the agreements would also need to comply with the requirements.
Thank you.
So, sorry.
No, go ahead, Vicky,
yes.
Sorry.
So I just wanted to add that this would also apply to a security SPV, and not only in a securitization, but a security SPV also being a non-operating type entity. That SPV would also need to appoint an operator, and that can be a professional trust company or an entity like that, and they would also need to enter into a written agreement. So these principles would, of course, also apply to other type of financing transactions. For instance, where you have a syndicated loan agreement, where you have a facility agent processing information on behalf of all the finance parties. So this must always be kept in mind, and each transaction would really need to be considered on a case-by-case basis, just to see if there's any operators processing personal information, and whether you need to enter into a contract to regulate that. Thanks, Ira.
Thank you very much, Vicky. Yes, I think it's so absolutely crucial that you do go and identify all your operators, because also if there were to be a data breach, of course, it would be the responsible party that would have to go and tell the regulator, not your operators. And you want to address that in the contracts as well, so that you don't have an issue if a breach occurs where you have to identify who is the responsible party, who is the operator. So I certainly think if you forget absolutely everything we've said today, just remember you need to go and identify your operators and enter into an operator agreement with them. So each private body and public body in South Africa would need, or subject to POPI and the Promotion of Access to Information Act, PIA, would need an information officer. The information officer would be by default the CEO. So POPI refers to the definition of information officer, in the definition of information officer, to the head of a private body as defined in PIA. And then, of course, PIA tells us when it comes to a juristic person, our information officer is the CEO or equivalent, or any person duly authorized by the CEO or equivalent, or a person acting as such. You would know by now that information officers must be registered with our information regulator. They have certain duties. For example, they must encourage compliance with POPI by the body. They must deal with requests in terms of POPI. They must work with a regulator. They must make sure that the organization has a POPI compliance framework, which is not defined in the Act. Personal information impact assessments must be done. I like to call those POPI audit questionnaires. And those POPI audit questionnaires want to determine what personal information you process. And of course, Vicky made it very clear that in structured finance, a lot of personal information is being processed. You want to know, is any special personal information processed? You want to know who that information is shared with, and so on. You have to have internal measures to deal with data subject access requests. You must have a PIA manual. And like I've said, these slides will be shared with you. The information regulator had some issues with their portal. And by the way, this happened under the GDPR, where registrations were required of controllers as well. So they've been having issues with their portal, and many of our clients have tried to register their information officers, but battled. The regulator said they're not going to take any action against anybody who didn't register the information officers by the 1st of July. So if you've been concerned about that, we have been given an indefinite extended grace period for doing these registrations, and hopefully the portal will be up and running soon. But bear in mind, even if you have a dormant entity, security SPVs, you would need an information officer. So you would have to appoint somebody to act as information officer, because you would be processing some personal information. And in groups of companies, please remember, each entity would have to have an information officer. I am of the view that the group could all appoint one information officer. We do know that the guidance issued by the regulator does not agree with this view, but I do think that it's a defensible view that you can appoint one person as a chief information officer for a group. Now, who can go to jail? I don't think anybody is going to go to jail, but there is some scope for personal liability in terms of POPI. For example, if somebody wants to access some of their information, some of their personal information in terms of POPI, and you then go and destroy, or you damage or alter the record, or you conceal the record, you hide the record, then you can go to jail. If you fail to have a PIA manual, you can also go to jail. And if you are issued with an enforcement notice and the information officer tells the organization not to comply with that notice, you can also go to jail. So very few instances where anybody is going to go to jail. You must do pretty silly things. And also any person, not only an information officer, could go to jail if you try and bribe or obstruct the regulator. So very important that you do decide who, if not your CEO by default, would you like to be your information officer. Must be a person with good administrative skills who would get back to people when they complain. Are you going to have a deputy information officer? You don't have to have one, but many of our clients appoint data champions for each team, say one for HR, one for marketing, and so on. And I think that works very well. Now, when can a responsible party process personal information? It's incredibly, incredibly important to note that you must always comply with 8 lawful conditions as far as the processing of personal information is concerned. This is the heart of POPI. You can never issue a paragraph-long POPIA opinion saying what you're doing is absolutely cool because it's in your legitimate interests. You must always check that you are complying with all 8 processing conditions. And if you're processing special personal information, there are further requirements. If you send information overseas, we have additional requirements, and so on. I'm going to go through these quickly. The first one is accountability. Accountability simply says comply with POPIA, and you need to be able to demonstrate that you comply with POPIA. How do you do that? You have your data protection policies, your subject access request policies, you've entered into operator agreements, you've got privacy policies, and so on. Processing conditions 2, 3, and 4 all go hand in hand. So first of all, the starting point is you must have a lawful purpose for processing somebody's information. So if your purpose is providing finance or dealing with structured finance, you must define what your purpose is for collecting information. And then you must only collect as little information as possible to meet that purpose. You must also have a lawful justification for your purpose. So my purpose can't, for example, be I'm a hacker. My purpose must have a lawful justification. One lawful justification when we're dealing with ordinary personal information is consent. But you don't have to have consent. You can process information if it is in the organization's legitimate interests or the legitimate interests of a third party or in the legitimate interests of the data subject, or you need the information for the conclusion or performance of a contract, or you're doing it in terms of a legal obligation, such as FICA. But of course, when we're dealing with red flag information, then we need to generally have consent or a law or a legal duty or legal right that requires you to process that information. So now you've got your purpose, a lawful justification, you're collecting as little information as possible. Don't collect information that you do not need. Then you're going to store that information. And POPIA says only store that information, record that information, keep record thereof for as long as you are authorized to do so. When are you authorized to do so? You are authorized to do so if a law says you must keep that information, if you've got consent, or if you have a lawful business reason, such as financing and getting money repaid to you, then you can keep that information. Information quality. There is a duty to take reasonable steps to make sure that all of the information in your possession is accurate and up to date, not misleading. If contact details, for example, do not work, you need to do something to update those contact details. Openness. We need to tell the data subject certain things. And this is a duty on the responsible party, not on the operator. The responsible party needs to tell data subjects who it is, what information it collects, why does it collect that information, who is it sharing that information with, is that information being sent overseas? And we generally deal with this in a privacy policy or privacy notice or privacy statement, whatever we want to call that document. And Vicky, I think this is a good place for you maybe to add some context to this in structured finance.
You know, in structured finance, I absolutely agree that the more practical way to deal with this would be in a privacy type policy. So this policy can be published on the website of a responsible party. And for instance, where we have an issuer of listed notes, note holders can always be made aware of that policy and the link to that policy at the website by way of a SENS notice. So I think that's quite an efficient way to deal with this condition. So there are also certain exceptions to this condition. I'm not going to deal with all of these exceptions, but some of them would include the data subject consenting to non-compliance with the requirement. So this is also something that we can keep in mind when drafting finance documents. So there can actually be consent that, that not all of the information set out in Section 18 of POPIA or Condition 6 be made available to the data subject. Then another exception would be where compliance is not reasonably practicable. So this is also something that can be considered. Also in securitization type programs, where an issue has various underlying assets, and it needs to notify all the obligors under those assets of the information required by this condition. So that's maybe something that can be taken into account. And then there's also an exception that where non-compliance would not prejudice the legitimate interests of a data subject. That's also something that might be of some use. So it really needs to be considered again in each transaction, and really something to take into account when you draft the finance documents. Thanks, Ira.
Thank you very much, Vicky. So security safeguards, it goes without saying, and Vicky has spoken to that just now as well, as far as the agreements between the responsible party and operator are concerned. But you need to implement reasonable organizational and technical measures to make sure that your data is secure. So organizational would be common sense measures, and technical will be your IT stuff. And you need to include that in your agreements with your operators. And our regulator has previously said that she wants to see the actual security features in these agreements. And now that I'm touching on operator again, I had a question just now as to whether a law firm would be an operator or a responsible party. Common mistake made in practice. People seem to think that because lawyers act on instructions from clients, that we would be operators. The majority of guidance overseas makes it very clear that lawyers are their own responsible parties. I also had a question about what if we share clients? If we share clients, could we be joint responsible parties? Often you could be, absolutely. The concept is not expressly recognized in terms of POPIA like it is in the GDPR. That is not surprising because we're based on the EU directive, not the GDPR, but certainly there is no problem with recognizing the concept of joint responsible parties in South Africa. And then one more question that I had just now before I forget to answer these is, what if we have conflicting laws? For example, if we have to disclose information in terms of the BE legislation, what happens when that conflicts with what POPIA says? First of all, POPIA says if you need to do something because there's an obligation in law to do so, you can do it. FICA would be another example. And if there is a conflict between POPIA and another piece of legislation, and the piece of legislation that gives the greatest and the most extensive protection to the personal information would prevail. That is usually POPIA, but we have, for example, seen that the National Credit Act in many instances give more protection to consumer credit information than what POPIA does. And sometimes we can overcome our obstacles in terms of POPIA, but we battle to overcome the NCA obstacles. Data subject participation. Our data subjects are given certain rights. Our data subjects can come to us and they can say to us, what information do we have? Where did we get that information from? Who did we share that information with? And they can also ask us for copies of the information, and they can exercise their right to be forgotten. So the right to be forgotten is, responsible party, you're no longer authorized to have my data, delete everything you have about me. But of course, if the responsible party has got a stronger right than mine, they can deny that request to delete the information. For example, I owe my bank money. I wish they would forget about me, but they don't want to forget about me. Okay, so moving on. Practical considerations. Please make sure that you have the relevant policies in place to deal with the processing conditions. Privacy policy, Vicky spoke quite a lot to privacy policies as well. A security compromises policy that identifies also who are your operators, who are your responsible parties. A record retention policy, very important, that sets out how long you're going to keep data for. Subject access request policies to deal with data subject access requests. And of course, your POPIA manuals. Incredibly important to have your POPIA manuals, because that is one of the reasons why our information officer can go to jail. Trans-border flows of information. If we want to send information out of South Africa, and this provision only applies if you are a responsible party in South Africa, and you want to send that information out of South Africa, then POPIA says you cannot do this unless you've put at least one safeguard in place. The safeguards would be, first of all, adequacy. And adequacy means I'm sending that information either to a recipient in a country with adequate data protection laws. Now, as far as adequacy is concerned, please remember that there is no other country that recognizes juristic person information. So as far as adequacy is concerned, we can never rely on a law when it comes to juristic person information. We can use binding corporate rules, which is basically a group data protection policy. And then we can send the information to other entities in our group, provided the binding corporate rules deal adequately with the conditions for lawful processing in terms of POPIA and restrict further transfer of personal information out of the recipient country. And then what we tending to rely on a lot these days would be a binding agreement. So a binding agreement would be very similar to the model clauses that we see in terms of the GDPR. And if you've dealt with EU entities, you will know that they're always chucking in the standard model clauses into all their agreements. Our version would be a transport transfer agreement that we can include in our agreements. We can also send information overseas if the data subject consents to the transfer. So I like including such a consent in our privacy policies, because if we've got this consent, then we don't need to go and enter into these transport transfer agreements. Just by the way, if you want to know which countries are adequate for human being information, we think we can assume that the countries adequate vis-a-vis the GDPR, where their laws are adequate vis-a-vis the GDPR, we think they are going to be adequate vis-a-vis POPIA. Of course, our regulator hasn't made a determination in this regard yet, but if you simply Google EU GDPR adequacy decisions, this list will come up. Please note that transfers to the USA is generally a red flag because the privacy shield has been invalidated. That agreement between the EU and the USA to share information has been invalidated by a court case called the Schrems II court case. So please always remember, when you're dealing with juristic person information, you can't rely on adequacy. If you are going to use a transfer agreement, it's important to identify whether the recipient is a responsible party or an operator, because the agreements are different, whether you're sending the information over to another responsible party or to an operator. Prior authorization. I remember about 2 months ago, many people were incredibly panicked about this provision. So prior authorization deals with the fact that on a once-off basis, you would have to go to the regulator and ask for permission to do certain processing activities. And this is regardless of whether you have, for example, data subject consent, or whether you have operator agreements in place and so on. This is actually having to go to the regulator and asking her for permission. Now, previously, on 1 July, we would have had to stop doing this processing while we were waiting for prior authorization or for certain time periods to run out. But the regulator has postponed the subsection, section 58.2, and said this is only going to kick in now on 1 February 2022. So that is that one provision that hasn't kicked in yet. Now, an example would be if you do credit reporting, you would have to apply for prior authorization. If you process information on criminal behavior on behalf of third parties, you would have to apply for prior authorization. We sometimes see this in groups of companies where one entity does shared services on behalf of the other entities. So for example, you do the FICA compliance on behalf of other entities. And while doing the FICA compliance, you do sanction screening. And during sanction screening, you can hit criminal behavior. You would have to get prior authorization for that. And if you transfer special personal information, not ordinary personal information, special personal information or information of children to countries without adequate data protection laws, or you haven't catered for adequacy by means of, say, binding corporate rules or a transport or transfer agreement. Security compromises. So this is commonly referred to as a data breach, but POPI doesn't call it a data breach. POPI calls it a security compromise. Now, the problem we have with this provision in terms of POPI is that it doesn't have a threshold. POPI says, if there is reasonable grounds to believe that the personal information of a data subject, so not the personal information of the responsible party, it would be a data subject's personal information, has been accessed or acquired by an unauthorized person, then note it is the responsible party, not the operator, who must make a comprehensive notification ASAP to the regulator and to the data subjects. Now, we have no threshold saying that a minor breach, for example, doesn't have to be reported. In terms of the GDPR, for example, we only have to report a breach if there is a likelihood that it can cause substantial harm to human beings. We don't have that threshold. The only other country that I'm aware of that doesn't have the threshold is Turkey as well. So yeah, you have to report every single breach to the information regulator. So I've just had a question here. Please provide some practical examples of where prior authorization will apply. Certainly things like you do sanction screening or investigations on behalf of third parties. You do credit reporting as a credit bureau, or in my view, even if you report non-payers to the likes of a credit bureau and so on. Then another question we have is, if your business premises have been looted or destroyed during the looting incidents, do you have to declare this to the information regulator? Absolutely. At ENS, we have certainly been dealing with lots of these cases. We're busy, I think, currently busy with 3 that we are reporting, where your physical documents have been looted because or destroyed or taken by somebody who wasn't authorized to have it. So yes, absolutely. I definitely do think that that is reportable. Moving on. So very important that your agreements do speak to data breaches. Your agreements must make it clear who is a responsible party, who is an operator. The operator must tell the responsible party there was a breach, and the responsible party then, of course, has the duty to go and report the breach. And your agreements should speak to cooperation between the parties to mitigate the consequences of a data breach and so on. Non-compliance, what happens when we don't comply with POPI? I have already mentioned that any person may lodge a complaint with the regulator. The regulator can then try and settle with the matter. If the matter is not settled, this can lead to an investigation. Of course, an investigation with a warrant can involve a dawn raid. And if anybody has been involved in a dawn raid, you would know that it is very disruptive. And sometimes they find things that they weren't even looking for. And then if a breach is found, you can be issued with an enforcement notice. Now remember, non-compliance with this naughty notice could of course lead to jail time. And if your information officer tells you not to comply with this enforcement notice, our information officer can go to jail. So penalties for offences in terms of the Act, like bribing the regulator, obstructing the regulator, not complying with an enforcement notice, range from 12 months in jail to 10 years in a nice South African prison, a fine of 10 million rand or both. But then, of course, we also have the civil side, and the civil side is strict liability. You wouldn't have to prove fault. All the data subject or the regulator on the data subject's behalf would have to show is that the responsible party breached POPI, and that breach caused damages. And POPI recognizes loss or damages in the form of patrimonial and non-patrimonial loss. So patrimonial is, of course, your monetary loss, but non-patrimonial would be your emotional, your psychological losses, and so on. POPI also speaks of aggravated damages, which is a lot of money because you've been very naughty, and interest and legal fees. So POPI would certainly have teeth. So that is the presentation, and as I've mentioned, it would be shared with you. I just want to see if we have any more questions here. We've got a question in terms of section 72. Would an internal data transfer agreement be required where personal information is being sent to an international office of the same group? Yes, I definitely think so. So an international office would be seen as a third party. It's not like you're sending the information to yourself, you're sending it to a third party. That office would be its own responsible party, a separate legal entity in terms of POPI, and you would need a data transfer agreement unless you've put another safeguard in place. So for example, if you have consent, or typically when it's a group, binding corporate rules would work very well here. So binding corporate rules would work well, or an intragroup data transfer agreement would work well there too. But absolutely, you would have to put some sort of measure in place to deal with section 72. Would credit reporting in terms of prior authorization include assessing a credit application when providing a loan to clients? No, I don't think so. I think if you're pulling credit information from the likes of a credit bureau or you're assessing an application, I don't think that triggers prior authorization. It is that actual reporting, the telling on that somebody is a bad payer. That is what, to my mind, would require the prior authorization. And I just want to add here that if you do have a code of conduct in place, for example, draft one has been published for the Banking Association. If you have a code of conduct in place, then you don't have to apply for prior authorization. That is basically the only way to bypass prior authorizations. If both parties are a responsible party, then do both need to report a breach to the information regulator, or is it only the responsible party who is responsible for the breach that reports the breach? Sometimes, depending on the facts, it would involve information which is shared between two parties, and then both responsible parties would have to report. But if the breach happens within the ambit of one responsible party only, it would be that responsible party who would have to report the breach. Does POPI override the Companies Act in terms of making a shareholder register available? No, absolutely not. If you're doing something because you're doing it in terms of mandatory provisions of a law, then absolutely it is POPI compliant to do so. Is Section 11 relevant when there is a sale of assets to an SPV? Section 11 is always relevant when there is processing of personal information. So Section 11, for those of you that don't know the numbers of the sections, Section 11 is that lawful justification provision, probably the most cited provision in terms of POPI. It is that provision that says you must have a lawful justification for processing personal information. One lawful justification is consent, but of course, others like legitimate interests or giving effect to a contract would also be in Section 11. By the way, it's interesting that you do raise Section 11, and I find that that is the section most often queried in terms of POPI, but it's not Section 11 that generally gives us the headaches. It's generally Section 15. And Section 15 says any further processing of personal information must be compatible with a reason for collection. Very little written about this provision in terms of the overseas guidance. But basically what they say is don't surprise the data subject. If the sale of assets and so on would be a surprise to the data subject, then it is probably incompatible and you would need consent. Cater for this in your privacy policies up front so that you are sale of asset POPI proof when that had to happen. Is a security SPV a responsible party or an operator? Vicky, do you want to touch on this a bit?
Sure, Ira, sorry, can you see me?
Yes, we can see you.
Perfect. So in this case, a security SPV would typically be a responsible party. Because the security SPV isn't a normal operating type entity, that SPV would typically outsource its functions to an agent. It'll usually be a trust type company, a professional trust company, and that operator will perform the functions of the security SPV. One thing that should be kept in mind is also just when you enter into those type of agreements with operators, when you deal with an SPV type entity, is just to check the MOI of that entity, because there's usually ring fencing provisions, and you must just have a look to see if the MOI allows that type of transaction. Thanks, Ira. I think, does that answer the question?
I absolutely think so. Thank you,
Thanks,
Vicky.
Ira.
So I think we have attended to all the questions that popped up in the Q&A and in the chat. If we did miss any of your questions, please feel free to get hold of either Vicky or Stephen or myself. We would be delighted to help you. But just in a nutshell, of course, I just want to summarize quickly. Remember, it doesn't matter whether an entity is domiciled in South Africa or overseas. If you process personal information in South Africa, you are going to trigger the provisions of POPI. You have to establish whether you are processing personal information as a responsible party or as an operator. In the slides, we've given you several examples of responsible parties, such as security SPVs, and who would be operators, such as a facility agent, and so on. Identify your operators. Make sure you amend existing agreements with them to cater for the POPI provisions. This is not a one-size-fits-all. You must make sure that, for example, that the security features that you add to the agreement fit the circumstances. Make sure you cover organizational and technical measures. Make sure you build in extra fat into those agreements. So you want to be able to do an audit on your operator. You want to be able to do some sort of a due diligence on your operator, and so on. So very important that you do go and look out for your operators, and also privacy policies, even though Vicky did mention that you don't always have to make those notifications in terms of Section 18 of POPI. If you have a privacy policy, make sure that you do deal with your aspects of securitization and finance and so on. And that is it from us. Thank you so much for joining our session today. Stephen, go ahead.
Just before we end, can you just touch a little bit on the timing of these things? So yes, we had the 1 July deadline. I think you did touch on it, but just to let people know that in terms of drafting these type contracts, operator agreements, and so forth, that until you do that, technically you're not in compliance, right? So
absolutely,
sooner the better in terms of getting this done.
Most definitely, Stephen. Thank you for that. I'm actually glad you brought that up. So a lot of people saw 1 July sort of like a deadline to a race, and once 1 July happened, then you could relax. You either made it or you didn't make it. If you didn't make it, those obligations are not going away. In fact, on 1 July, this journey actually started. So if you don't have these agreements in place, then get them in place ASAP, because you would already be in breach of the Act. But certainly if you go and look at the ICO and you Google ICO journey GDPR, you will see that not everybody met the GDPR deadline either 3 years ago, but that didn't stop them from complying. And the ICO said it is a journey. Make sure that you go towards compliance ASAP. And I think that is it from us. Thank you so much. And if you do have questions, please contact us. Bye-bye.
Thanks, everyone. Bye-bye.